When the Campbell Soup Company sued a political candidate named Shelby Campbell, it made headlines for all the obvious reasons. Same last name, a slogan about soup, and a campaign image that looked like the company's famous red and white can. But the lawsuit raises deeper questions. Can a corporation use trademark law to stop a political candidate from using a parody of its brand? Or does the First Amendment protect political expression? I'm Scott Hervey, a partner with the law firm of Weintraub Tobin, and I'm joined today by my partner, Richard Buckley. We are going to talk about Campbell Soup Company versus Campbell for Congress on today's installment of The Briefing. Richard, welcome back to The Briefing. It's good to have you back.
Thank you, Scott. It's great to be back.
It's interesting, Richard. It just dawned on me, but you've been getting all of the artwork cases or cases that involve artwork. First, you got the banana. Now you're getting soup. What's going on here?
I know, and I got the basketballs too.
That's right. That's right. Yeah, you did. Well, okay.
I,
You're our art guy, I guess.
I think the universe is trying to tell me something. But
Yeah. Well, all right, let's start with the background, shall we? So, Shelby Nicole Campbell is a Detroit area candidate for Congress who, according to her complaint, has been nicknamed Soup ever since she was a baby. I don't know about you, Richard. I would hate to have that nickname. According to her motion to dismiss, that nickname has been part of her family identity for decades. She even had a license plate that reads X Soup 1. When she announced her candidacy, she decided to lean into that nickname with the slogan Soup for Change. The phrase, she said, symbolized community care and political reform.
to promote her campaign, she created a simple design, a stylized soup can image with the phrase "Soup for Change," generated with an AI art tool. The design appeared on about 300 stickers, mostly handed out to supporters. Some people gave small donations, but as her filing emphasizes, donations were quote unquote appreciated but not expected. There was no merchandise line, no sales for profit, and no soup involved.
Yeah. And I think the best way to I guess visualize her design is it looks just like the Campbell's tomato soup can, or it looks very much like the tomato soup can, but it says like soup for change instead of, I think, Campbell soup. Okay. So in September 2025, Campbell Soup Company sent our candidate a cease and desist letter claiming her design infringed its trademark and its trade dress. She says she promptly complied, stopping production and publicly clarifying that she had no affiliation with the Campbell Soup Company. She probably should have done that to begin with. But a few weeks later, Campbell's filed a lawsuit claiming that some social media posts, some sarcastic and some hostile, were evidence of actual consumer confusion.
In her motion to dismiss, Campbell, who by the way is representing herself, calls that move overreach. She writes that plaintiffs are attempting to transform a lighthearted political pun and personal nickname into federal trademark litigation.
All right, so let's talk about the claims. Campbell's Soup complaint alleges trademark infringement, false designation of origin, and false endorsement under the Lanham Act, all based on the Soup for Change slogan and the can design. Shelby Campbell's motion to dismiss responds that this complaint fails to allege a plausible claim of trademark infringement, false designation of origin, or false endorsement.
Her first major argument is that there was no use in commerce. She says that the challenged use of soup for change was political campaign speech, not a source identifying mark for goods or services. Under the Lanham Act, there has to be use of a mark in connection with the sale or advertising of goods and services. Handing out free campaign stickers doesn't meet that test.
Right. At least she alleges that.
Correct.
She relies heavily on a Sixth Circuit case that protected a non-commercial gripe website. The court said that if the defendant's use is commercial, Then and only then do we analyze this use for likelihood of confusion purposes.
So by that logic, Campbell's use wasn't commercial at all. She wasn't selling anything. As the motion puts it, Ms. Campbell was running for Congress, not selling soup, shirts, or any product branded soup for change.
Now, even if the court were to somehow find use in commerce, the motion argues that there's still no likelihood of confusion. She argues that her campaign was clearly political, not commercial. She wasn't using Campbell's at all, just soup, her nickname, and her own last name. As her motion to dismiss notes, quote, plaintiffs sell soup and food products. Defendants are selling a political candidate to voters. These are entirely distinct arenas with different audiences and purposes.
She also points out that she explicitly disclaimed any corporate affiliation. On social media, she joked that Campbell's would never endorse me. Those kind of statements, she argues, substantially reduce any risk of confusion. And when it comes to intent, her motion reminds the court that good faith use of one's own name is not evidence of bad intent.
And then there's parody, another key defense. She calls her design an artistic, satirical image and quotes the Fourth Circuit Louis Vuitton versus Hot Diggity Dog case, where the court said a parody communicates simultaneously that it is not the famous trademark, but is only satirizing it. Her motion argues that no reasonable person would think Campbell Soup Company was endorsing a political candidate through a sticker that literally pokes fun at the brand.
And that brings us to her First Amendment argument. The motion says, quote, the First Amendment fully protects defendants' expressive political speech and parody.
The brief then argues that Rogers versus Grimaldi, a case that we talk about here a lot on the briefing, also provides a defense. Her motion says her soup for change theme easily satisfies the Rogers test. It's relevant to her nickname Soup, and she has made it clear that she wasn't endorsed by Campbell's.
And she ties it all together by invoking the Supreme Court's Jack Daniels versus VIP Products decision. While that case limited parody protection when the parody becomes a product brand, it reaffirmed that expressive parodies like campaign slogans are shielded when they're not being used to sell goods.
Right. The crux of that case was the analysis falling outside of the Rogers test when the use of the mark acts as trademark use as opposed to non-trademark use, meaning use of a word or words as the title of a single artistic work, or the use of brands in third-party works, such as maybe, I don't know, the use of a Coca-Cola bottle in a television show where the character is drinking Coca-Cola.
Yeah, and her brief sums it up and puts a bow on it by stating, defendant's use was not in commerce and not likely to confuse or mislead anyone. It was an expressive, non-commercial use, fully protected by the First Amendment.
Okay. Right. So on its face, she makes some really good arguments, right? But I think that there could be an issue with the fundamental, like the fundamental piece of her case, which is that her use is not trademark use, right? It's not use in commerce and it's not trademark use. So let's take a look at this case, Hershey Company versus Friends of Steve Hershey, because as I said, I think there's going to be an issue there. And this case is quite similar to hers, and it potentially provides some insight into how this court might actually address this case.
I totally agree. That case involved Maryland State Senator Steve Hershey, who ran a campaign using signs and promotional materials that mimicked the Hershey Company's well-known chocolate bar logo and trade dress. I actually looked it up online, and the sign is exactly a Hershey bar. So very similar to the instant case.
Right, right, right. The campaign signs used, as you just said, the familiar brown background and silver lettering with Hershey replaced by Hershey, right? In the same distinctive font, clearly evoking, the candy bar packaging. The Hershey Company sued, claiming trademark infringement and dilution.
Senator Hershey's defense was that his campaign materials were political speech, and thus protected under the First Amendment. He argued that because the signs were part of an election campaign, they didn't constitute quote unquote use in commerce under the Lanham Act.
But the court didn't buy that argument. The District Court of Maryland found that political activities, including the dissemination of campaign information, hosting fundraising events, and soliciting donations, are services within the meaning of the Lanham Act. In other words, campaign activity is a kind of is a kind of commercial use. And if I may add, the United States Patent and Trademark Office has a tool called the ID manual. And what this does is it helps applicants who are filing a trademark application correctly identify goods or services in a manner that's been accepted by the USPTO. And this ID manual has a vast number of identification or descriptions of services, all related to the political field. So, political consultancy, political fundraising services, political lobbying services, business management of political elections, printed questionnaires on a specific matter of a political issue, political fundraising. So, clearly, the Patent and Trademark Office thinks that a wide variety of services related to the political arena, including political fundraising, are uses in commerce for which a federal trademark application may be filed.
Yeah, and that's compelling corroborative evidence to support the court's critical point. The Hershey court essentially held that because campaign materials are used to promote a candidate and to generate donations, they fall under use in commerce, even if the message is political and not commercial in the traditional sense.
Right, right. And the court rejected Hershey's First Amendment argument, finding that his use of the Hershey's logo wasn't parody or commentary, it was just branding for his campaign. And I think that's the case here.
Right. And what makes the Hershey case so relevant to the Campbell's Soup lawsuit against the political candidate, in both cases, the defendants tried to invoke political speech as a shield, arguing that their use of a famous brand's mark or trade dress was expressive or protected by the First Amendment.
Right. But just like in Hershey, the political candidate here, Shelley Campbell, is likely to face the same challenge that her campaign activities constitute use in commerce and that her use of the Campbell's mark wasn't parody or commentary. It was simply borrowing a brand's identity to promote herself politically.
Right. And the Hershey case shows that courts are not inclined to give politicians a free pass on trademark law when their campaign branding crosses into commercial use or risks consumer confusion.
Right. And it reinforces that political campaigns are not beyond the reach of the Lanham Act. And unless a candidate can tie the use of a brand's mark to genuine commentary or genuine parody or genuine critique, courts are likely going to view it as infringing commercial activity. So, what do you think the outcome is going to be here, Richard?
She'll lose, except that, I mean, if she has ceased use and they're seeking injunctive relief, I mean, the argument could be made that, that it's moot and that there's no real controversy anymore. But I think from a substantive standpoint, Campbell Soup has the better argument, as evidenced by what the court did in the Hershey case some 10 plus years ago.
Right. I agree with you. I think that she will hear our podcast, realize that her soup is boiled over, and that she's going to settle her matter with the Campbell Soup Company and consent not to use their brand anymore, and they'll dismiss the case.
But it seems like she's already done that. But that's no guarantee that she couldn't do it again. So they might, Campbell Soup may still be entitled to some form of injunctive relief.
Yeah, right. But I mean, do they really want to pay their lawyers to go after a candidate who has already stopped using their branding? This case should settle. It should be one of the ones that settle. And by the way, if I was the judge and this got before my on my docket, I would hammer the lawyers that they should resolve this thing and not waste the court's time.
It
So,
can definitely be worked out.
yeah. Well, Richard, I mean, it's not every day that trademark law and political speech and soup collide in such a colorful way, right? A congressional candidate named Campbell, nicknamed Soup, using an AI generated soup can image to talk about change.
Hello again. This is Richard Buckley, back for some bonus coverage relative to the Campbell Soup versus Shelby Campbell case. Right after we finished the episode that you just consumed, we received word of a significant development in the case. Scott has asked me to provide this update. It has been reported that Campbell Soup and candidate Shelby Campbell reached a settlement, as is often the case in civil litigation proceedings. The two key points of the settlement that are being reported: one, uh, candidate Campbell is to cease using Campbell Soup's trademark logo, and also to remove certain disputed images, including but not limited to any design that uses Campbell's mark and trade dress. She is to do this by November 21, 2025. Number two, candidate Campbell is free to use the term soup in her campaign. So, good news for candidate Campbell. She can still use her nickname Soup. And good news for Campbell Soup. Their trademark material won't be out there without their permission. If you're still interested in the case, I encourage you to look at some of candidate Campbell's colorful comments online describing her settlement and her path forward. Clearly, she is not under a non-disclosure agreement as part of the settlement. Anyway, thank you for joining the briefing. Thank you for listening to this bonus coverage. This is Richard Buckley for myself and for Scott Hervey. Thank you again.
Thanks again for being my co-host, Richard. It's always great to have your insights.
Thank you, Scott. I appreciate it.
And thank you, our listener or viewer, for joining us today on the briefing. If you found this episode helpful or interesting, or if you found yourself hungry for soup afterwards, please take a moment to subscribe, like, and share it with your network. We'd also love to hear from you. Leave us a comment or review and let us know what topics you would like us to cover in future episodes. I'm Scott Hervey, and I'll see you next time on the briefing.